Welcome back to the Financial Symmetry Show. Chad and Allison here with you this week, and we've got a good one for you this week. We put a priority here at Financial Symmetry on continuing education, keeping our knowledge up to date on the things that impact our clients, because we're working with clients daily. With that goal of the continuing education, Allison attended a conference last week in Boston, the Ed Slott IRA conference, and we're going to walk through some of the takeaways from that conference today. And I liked how you started off your notes, Allison. We'll jump into this. The IRA Beneficiary Form is what we're going to be talking through. It's like the skinny kid that gets picked last on the playground, right? It's the thing that people leave out a lot of times too, whenever we're starting accounts. But this form really gets no respect. I guess like he probably used a Rodney Dangerfield example in that one, but he said it can really be the Michael Jordan of estate planning. I like the way he put that. So because the will does not cover these IRA beneficiaries, right?
Exactly. Yes. So that is a common misconception, is that I created my will, everything will pass through the will. And so today we're going to be walking through beneficiary mistakes that people make on their IRAs and their retirement plans. And as you mentioned, Chad, on the path to your ideal retirement, a lot of us accumulate very significant asset balances in these IRAs and in our employer-sponsored retirement plans. We may not spend all of those during our lifetime. We may want to leave them to our loved ones. And we want to make sure that those pass according to our wishes. Unfortunately, a lot of people make very, very common, easy to correct mistakes. So today we're going to be walking through some of those. And one of the little luxuries I like to do when I'm traveling for business is just have one night in the hotel room to order room service and catch up on some reruns of my favorite sitcoms. So on this particular trip, I watched a little bit of Modern Family, and I really think no one quite writes mistakes and misunderstandings like Modern Family does. So we'll use some of those examples as we walk through today. But thinking about these accounts, the main estate planning documents, this might be the client's largest asset in their estate. An IRA or 401k, 403b, really controls the distribution of money that they've worked and saved for their entire working life, will save certain types of taxes depending on the beneficiary designation. So this is something that can really determine where the money goes, how much of it is subject to tax, and what happens to your life savings. But unfortunately, it can't be found by most people in America. So we want to think about this very simple form that we may take for granted.
Yes, and as we jump into this, I love episodes like this because many times there's little kernels, little interesting things that you might have heard in the past, and you're like, oh yeah, I need to go double check that to make sure I've done that myself. So hopefully you'll get some info that you could look at or talk to your financial advisor, or if you're not working with an advisor, of course, you can check out financialsymmetry.com. We have many articles on a lot of different topics that impact your life and your retirement. And you can sign up for our weekly newsletter or our monthly newsletter there. All right, let's kick this off, Allison. So here in some of these Modern Family references, and we're going to get into the first one, a common mistake. And this is, of course, mainly not naming a beneficiary.
This one's very, very simple. And we see the estate named as the beneficiary fairly commonly. That's a common thing to do. Say, I put my will in place. I'll just say estate, and then it'll go according to my will. Unfortunately, what many people don't realize is that if you have those beneficiary designations in place and you've named people as your beneficiaries, those IRAs, those retirement accounts will not pass through probate. So they won't be subject to the red tape, the additional fees that probate assets that are named through the will be subject to. This could also lose the stretch option. So certain types of beneficiaries can stretch out those IRA distributions over the course of their lifetime, potentially saving a lot of money in taxes, because you could take smaller distributions over a longer period of time, likely paying a lower overall tax rate than taking a large distribution at one time that will be subject to likely a higher tax rate because of the amount of that distribution. So we want to think about definitely naming beneficiaries. The estate is not a person, so it cannot be a designated beneficiary. Unfortunately, cannot be subject to those more preferential tax treatment that IRAs have.
One that we commonly see, and if we've dealt with that in the past, when an estate has been a beneficiary, it takes a much more time and often not the most desirable outcome for the beneficiaries. It's likely not what the deceased might have been looking for as well. So as we move into number two here, assuming your employer or your custodian where your account is held has your original beneficiary designations on file. That is you know what it is when we assume things, right? There's the classic saying there, but I know you had an example of that too.
So a lot of times what we see is clients or individuals will assume that whatever they set up when they started at their job, oh yeah, I set that up when I started at my job, that's still on file. And I think about this a little bit in terms of Modern Family as well. There was one episode where Claire had a job interview via Zoom with an organization company. And something happened to her on that day. What did Phil always need to do in the Dunphy household? He always needed to fix that step, right? He never fixed that step. And Claire's leg goes through the step, and she has to conduct the interview via Zoom with her leg stuck in the step. And Luke and Phil are holding this bookshelf behind her that looks really organized. The whole thing goes toppling over, and hilarity ensues as usual. And I can think about this in terms of these custodians. What have we seen really since COVID and over the past 10 years? We've seen so many custodial changes, mergers, acquisitions. We have clients constantly. Their 401k is moving from Prudential to Fidelity to Schwab. It's changing providers. Maybe it's now at Ameriprise. They don't have the form anymore. You filled that out when you started working for your company 10, 15, 20 years ago. They may not have that on file anymore. So we see that fairly consistency when we'll log into the accounts. We'll look in the beneficiaries section. It's blank. So what happens if you pass away and they do not have that? You could run back to number one where we're going through the estate because no one can find that beneficiary form. So really the onus is on the account owner or the taxpayer to maintain good records here. Make sure you're reviewing these every so often and updating. If you don't see that your 401k or your IRA provider has that on their record, we want to go ahead and submit a new form, get that updated to make sure it's in line with your wishes.
Yeah, it seems assuming is a main theme here. And when you're dealing with financial planning, assuming can often be the wrong strategy because you might have handled something in the past, but life events occur and things change. And that often presents difficulties and many times emotional issues, right? Or emotional moments where you're not thinking of financial planning first, especially beneficiaries. So let's move into the third one here. Another assuming option here is, or a common mistake. It's assuming that your spouse will automatically inherit the money in your IRA or your 401k or 403b.
Thinking through these, I was thinking a lot about Jay and Gloria because Jay and Gloria, their second marriage, right? Jay has a stepson in Manny. Then they have a child of their own. He also has 2 adult children. So it's really a modern family with a little bit more of a complex arrangement. And unfortunately, we're kind of going back to the idea that we don't always update. We make assumptions that, maybe Jay got remarried to Gloria. They updated their estate documents. He thinks things are still in line with his wishes, but he may have his first wife, Dee Dee, still on that IRA beneficiary designation form. So if something happened to Jay, it's very possible that his ex-wife could inherit that money. So those are some things we really want to think about. It happens all the time. We see it in the news where an ex-spouse will inherit IRA or 401k money because you didn't change the beneficiary designation. And again, those assets pass outside the will. They're non-probate assets. So if you updated your will and you made the changes there, it might not apply. Something else to keep in mind here is ERISA plans. So ERISA stands for Employee Retirement Income Security Act. Those have spousal protection. IRAs do not. So in that ERISA plan, say your 401k or your 403b, you want to designate your adult children instead of your new spouse. That's all fine and good. You can do that, but your spouse still does have claim to those assets. If you name another beneficiary, your spouse has to sign off on that. So they need a spousal waiver that does have to be signed. And unfortunately, in these situations, a prenuptial agreement might not work because prenuptial agreements are signed by a fiance, not a spouse. So they have to be those spousal agreements. So some things you might want to consider there. We can talk about that a little bit more in number 4 as well. And in these as well, we have a case study article in the New York Post here of a widower who lost money to his in-law. So she never updated her beneficiaries, and that money was inherited by her sister instead of her husband, even though she had updated her estate documents. So there's examples of these all over the place to show just how important updating and thinking through these beneficiary forms can be.
And we'll have links in the show notes to those articles and the articles we're mentioning, and also some slides with the detail, because there's going to be a lot of things that you might want to go back and double check in this episode. We'll have slides in the YouTube accompanying video of our podcast. So as we move to number 4, the common mistake here is another assumption. And this is really applicable to the Modern Family reference, right? If you have a non-spouse beneficiary, will they still receive the funds from your IRA or 401k or 403b if you remarry?
Yeah, so this one, it's very similar to the number three that we just went through. But we can imagine, let's say, Jay, he has a second marriage to Gloria here. Maybe he wants his adult children, Mitchell and Claire, to receive the funds from his prior employer plan. And he wants to leave other assets to Gloria. Because, while he was raising Mitchell and Claire, he worked for this company. That's when he built up those assets. He feels like he'd like Mitchell and Claire to remain the beneficiaries on that account. So he leaves them as they are. Even if they're the named beneficiaries, Gloria would need to sign off on that non-spousal beneficiary form. And we do have a case here of children that were disinherited in this case. So spouse named, a man had his wife named as the spouse. She predeceased him. He never changed the beneficiary form to update. And his stepsons, who were named in his will to receive everything, did not receive it. It went through the probate estate and ultimately went to his siblings and other family members. So importance of doing that proper planning, making sure that things are set out the way that you'd like them to be, because you don't want your family to have to go to court and fight against these. Court can be very expensive, and the outcome might not be what you would expect.
Another great reason to have an advisor in your life that assures things are getting done, because these are easily missed items in your life that you forget about when those events happen. So it's good to have an annual checkup, annual review where you're just doing a cursory glance to make sure things are still the way you want them on those forms. So, number 5. Okay, this is a common mistake we see when we're setting up accounts for new clients in particular. And it can be a stopping place sometimes because they're not sure, especially with young children. But in this circumstance, you get into even more details, I know, with the blended families of a contingent beneficiary, not your primary beneficiary. It's the second level. What if something happens to both of you at the same time if you're married?
We're looking at, most people are going to name their spouse as their primary beneficiary, and then maybe their children as contingent beneficiaries. If they don't have children, maybe they're going to name a charity. So thinking about this situation again with Jay and Gloria, let's just say Gloria predeceases Jay, and he had only named her as his beneficiary. We have to wonder, in this situation, would Manny, Jay's stepson and Gloria's son, have the same rights as Claire, Mitchell, and Joe? Joe being the baby that they had towards the end of the run of Modern Family, if Jay never legally adopted Manny. So that is a question. And we would think, based on the relationship we saw during the run of the show, that Jay would have wanted Manny to be included in some way. And we did see a case like this, Herring versus Campbell in 2012. A man named John Hunter worked for Marathon Oil Company, named his wife as a beneficiary, did not name contingent beneficiaries, and his stepchildren were ultimately disinherited. So there are situations like this that can come up. It gives you a lot more flexibility if you name those contingent beneficiaries as well. So the money passes directly. Again, you want to get that preferential tax treatment on the IRA distribution rules. This also removes the ability of a wealthy or an older beneficiary to disclaim the portfolio. So this is not something that we think of happening often, but let's just say, you named a beneficiary, you named your adult son as a beneficiary, and you named a charitable organization as your contingent beneficiary. Your adult son could say, I really don't need this money. I know that was dad's favorite charity. I'd like it to go directly to the charity. He could disclaim his portion. That money could pass tax-free to the charity, because charities are not taxable entities. So that could be an outcome that your beneficiaries might want to consider, but they can only do that if they are a named beneficiary. So that is something to think about. You could also name, if you don't have, a person, again, you could name a charity as a contingent beneficiary, or your donor advised fund. I know we talk a lot about donor advised funds. Unfortunately, they can't be used for qualified charitable distributions, but they can be named as an IRA beneficiary. And again, that money would pass tax-free.
Very nice. Some other options there on the charitable side. So that's a good way to think through that. Now, as we move into number 6, the common mistake here is maybe being a little too trusting. And we see this potentially in families with children. Also, maybe if you have a friend that you're trusting, that you want to take care of some other people in life. If you name one person, and we got a great example here from Modern Family, and you're expecting them to take care of the rest because the others might not be as responsible, that can backfire on you, right?
Ed Slott referred to this as nice guy messes up. We call this naming one person and expecting them to take care of the other beneficiaries. So in the Modern Family example, Phil and Claire, they have 3 children. One is a little sharper than the others, right? Alex is, very smart. Haley and Luke, maybe not so much, the way they're portrayed on the show. So we could imagine Phil and Claire thinking, maybe we should name Alex as the sole beneficiary. She'll take care of Haley and Luke. However, what could happen here, there's no do-overs. There's no 60-day rollover once you've distributed money from an IRA. And this happens quite frequently where you'll name one person, maybe you tell them privately or in a letter, in a writing, that you want them to distribute the money, split it with the other beneficiaries. So we can imagine Alex, maybe pulling out, let's call it $1 million from the IRA. That would all be taxable to Alex because she was the sole beneficiary. She pulled it all out. She gives a third of that to Luke and a third of it to Haley. And they fairly quickly spend that money however they see fit. Next tax season, Alex is hit with a very large tax bill, probably most, if not all, of her third of the inheritance going to pay the taxes on that total $1 million. So this is a mistake you really want to think about. If you have intentions that you want to leave money to multiple people, name them all. Don't name one person and expect them to split that up for you.
Yes, and as we get to number 7 here, this is a common mistake and an example of how laws change. And when they change, it can disrupt your original plans that you thought you had in place that were going to do the things you wanted them to do at that time. And we're talking about the Secure Act here, the original Secure Act, 2019. You might have done some planning towards the end of that year to make sure you had the appropriate beneficiaries set up. You might have had a trust in place. Now there's been some changes, multiple iterations of this act that has maybe called some of those things into question, right, Allison?
Beneficiaries used to be able to spread those distributions from an IRA, an inherited IRA, over the course of their remaining life expectancy. The Secure Act sped that up, and they want those accounts distributed fully within 10 years of the date of death. So any trusts that were put in place prior to the Secure Act may have stipulated that the beneficiary, the trust take the annual required minimum distributions according to the life expectancy. However, if that trust is still in place today, that would all come out within 10 years to the beneficiary. So we want to really think about beneficiaries who you're wanting to put money into a trust for. Maybe they're minor beneficiaries, and in those cases, that is typically more appropriate. However, we think of a beneficiary who may have spending, gambling, debt problems, and you may want them to only receive smaller portions at a time, or someone who's not able to care for themselves appropriately. When I was in Boston, one of the episodes of Modern Family that I was watching in the evening was an episode where Cameron and Mitchell were trying to sleep train Lily, and Mitchell wanted to Ferberize the baby, as Cam put it, and Cam would get up every time she cried. And one time in the middle of the night, Mitchell catches Cameron and Lily watching Scarface. And Cameron notes that, she loves the nightclub massacre scene. And of course, she's a little baby. We're assuming this isn't affecting her little brain, but let's just extrapolate and say it does, and she's scarred from that late night Scarface for life. And she develops a spending addiction, and she's really spending out of control. They might want to consider putting money into a trust so she doesn't have her access to that all at one time. However, if that trust was put in place prior to 2020, it may not still work. So it's really time to revisit those and think about your beneficiaries who maybe, it's not the best idea to leave money to them outright, but we want to look at new trust options, and maybe if there are other assets that we want to go into the trust instead of IRA or retirement plan accounts.
So if we're summarizing here, I love the takeaways that you had there, the ideal kind of scenarios. So let's walk through some of those.
Yeah, so really like we talked about in the beginning, this one simple little form can be the Michael Jordan of your estate planning documents. For most retirees, this is going to trump all other estate planning documents. You really want to avoid litigation. You want to avoid your beneficiaries having to go to court and contest what your beneficiary designations were, or that there were no beneficiary designations. Review these forms annually. And I say forms, but a lot of times this is online. You can log into your accounts and look at it. If you are a beneficiary, consider disclaimers. Is this a situation where maybe my adult child is doing very well for themselves? Maybe they won't need the money and they'll want to disclaim it so it could go to another beneficiary. Again, post-death fixes are expensive and may not always work. The average private letter ruling from the IRS costs $12,000. Going to court can eat up those estate assets in legal fees and the desired results. may not be achieved. Also want to be careful with legal advice. That was one thing we really talked about, is just the advice that my lawyer told me to may not always be good enough with these IRA beneficiary designations. You really want to think about how those are going.
Yeah, and as we wrap up here, he talked about 3 of the most desired estate planning objectives, and that leads us into that progress principle idea.
Yeah, for most retirees, their 3 main estate planning objectives are: they want larger inheritances for their beneficiaries, more control, and less tax. And filling out those beneficiary forms, making sure everything is in line, helps you achieve those 3 goals. And as we're thinking about our progress principles, coming back to Phil Dunphy, we know Phil has his philosophies that he likes to reference throughout the series. I had a philosophy here: success is 1% inspiration, 99% perspiration, and 2% attention to detail. So I think taking a look at these beneficiary designations is hopefully very little perspiration, mostly attention to detail. And hopefully this episode gives you a little bit of inspiration to get that going. So taken away from this, review and update these IRA and retirement account beneficiaries. Talk to your beneficiaries where appropriate. Let them know what to expect. And then talk to your financial advisor about strategies to minimize the taxes for your beneficiaries and for yourself.
Again, an area that probably does not get enough attention or thought around it, but we have over 500 blog posts on different areas that you may be interested in, and you can search a topic on our website on the Financial Symmetry blog. You can also look up a video if you'd rather watch, or listen to many of our almost 200 episodes now that we have on our podcast. Thank you for joining us today, and look forward to talking to you again in 2 weeks.